Hello, everyone. For folks joining, we'll get started in just a minute here. Hello, everyone, and welcome to the Environmental Law Institute's annual Supreme Court Review and Preview for 2024. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at ELI. Each year, we hold a program that offers an overview of key rulings and major takeaways from the field of environmental law from the Supreme Court's last term. We also use this program to discuss cases that have been granted review or are likely to be considered by the justices in the upcoming term. We're so excited to have you joining us this afternoon. Before we get started, I want to take a moment to thank our fantastic expert speakers for taking the time to join us again this year for this program. We so appreciate their continual excitement and willingness to spend their time with us. Today's event will be recorded and posted to the ELI website within a few business days of the program. So if you're unable to view the entire webinar, be sure to check back to the event webpage to see the recording. We will be taking audience questions at the end of today's program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. There's no need to wait until the end of the program. While the chat will be open for you to post observations, please put any questions that you wish for our speakers to address in the Q&A box rather than the chat. We will not be tracking any questions that come in through the chat. They'll need to be in the Q&A. I'll now go ahead and turn things over to our wonderful moderator, Jay Austin. Jay is a senior attorney at ELI and is the editor-in-chief of the Environmental Law Reporter. He co-authored a recent research report on the Supreme Court titled The Supreme Court Environmental Regulation and the Regulatory Environment. The report surveys recent and past decisions of the Supreme Court, examines their impact on the fields of environmental law and regulatory law, and evaluates how they might affect various conservation strategies. We'll drop a link to that in the chat so you can check it out. And Jay, I'll hand things over to you. Thank you so much.
Well, thanks, Madison. Good morning, all from overcast Portland, Oregon. Good afternoon to many of you. Happy first Wednesday this year, and welcome to our 2024 Supreme Court Review and Preview. For the third straight year now, we are looking back at a Supreme Court term with major implications for environmental and regulatory law, and ahead to a term with the potential for even more. To make sense of all that, we've again brought back our all-star team. These folks have resisted lucrative offers from other webinars and other institutes to be here with us today. Once again, they are first, Sharon Jacobs, a professor of law at Berkeley Law School, where she teaches energy law, environmental law, and administrative law. Gerald Torres is professor of environmental justice at the Yale School of the Environment, as well as professor of law at Yale Law School. And finally, Robert Percival is the Robert F. Stanton Professor of Law at the University of Maryland's Carey School of Law and directs the environmental law program there. Bob also was a law clerk for Justice Byron White. Each of our panelists will start by taking a few minutes to highlight a decision or two from the court's past term. We'll then have a brief discussion before turning to preview the upcoming term and things to come. It is a very full docket this year, but we will still try to leave some time for audience Q&A. So please do, as Madison said, enter your questions into that box, not the chat, as you think of them, and we will try to get to as many as we can. So starting off with our review, Sharon, we truly are all administrative lawyers now. Once again, I think third straight year. I'm going to lead off with you and be very interested to get your take on some major decisions from this term.
Well, thank you, Jay. It's so good to be back here with the panelists, with all of you talking about what was a very consequential term for environmental law in the Supreme Court. And some of the most consequential cases weren't squarely environmental cases at all. They were administrative law cases, although one, Loper, had a natural resources factual background. But because so much of environmental law is administrative law, the trio of cases I'm going to talk about may end up having a profound impact on environmental rulemaking and enforcement of environmental statutes. So just to give a little bit of context at the beginning here, all three of these cases came out at the very end of the term. There is no veneer of bipartisanship here. All three cases were 6-3 or 6-2 in one case splits, with the more conservative justices in the majority and the liberal justices in the dissent. And all show a desire for enhanced judicial oversight of administration. So I'm going to start out with what was maybe the blockbuster administrative law case, Loper Bright versus Raimondo. This was a case that was very on brand for this Supreme Court. I saw that Justice Kavanaugh just referred to this case, to Loper recently, as a course correction. I think it was much more than that. It was a case overruling a 40-year-old decision by reinterpreting an 80-year-old statute in a way that rolled back agency authority and did so by enhancing the power of the judiciary. So the underlying challenge in this case involved the Magnuson-Stevens Fishery Conservation and Management Act, under which the Secretary of Commerce and the National Marine Fisheries Service can promulgate regional fishery management plans. And a regulation in 2020, as part of those plans, provided for at-sea industry-funded monitors on boats in the New England Fisheries Program. The plaintiffs in this case were herring fishermen who might have to pay for these monitors, and they're quite expensive, up to about $700 a day. So they challenged these rules, and their argument was that the act didn't authorize the secretary to create this particular program. The DC Circuit found in favor of the government, and notably did so by upholding the secretary's interpretation of the act as reasonable under the 1984 case Chevron versus NRDC that most, if not all of you, are familiar with, but that was a case that obligated courts to defer to reasonable agency interpretations of ambiguous statutory provisions if the agencies had been authorized by Congress to administer those statutes. So the DC Circuit deferred to the agency. The First Circuit came to a similar conclusion in a companion case called Relentless, and the Supreme Court granted certiorari on a single question, which was, should Chevron be overruled or clarified? And as we now all know, the Supreme Court did choose to overrule Chevron. Chief Justice Roberts opted to write this opinion himself, again, for the 6 conservative justices in the majority. The 3 liberal justices in dissent. Justice Jackson was recused from Loper because she'd actually heard oral argument on it on the DC Circuit, although she didn't decide the case, but she was able to participate in the Relentless decision. So the reasoning of the court here was essentially just that Chevron was flat out wrongly decided. It was so wrong it should be overturned. And the slightly more detailed version of that is that they found Chevron was inconsistent with the language of the Administrative Procedure Act, again, a 1940s era statute that says courts reviewing agency action shall decide all relevant questions of law and interpret constitutional and statutory provisions. Now, the court has been aware, of course, of this statutory language since the 1940s, and certainly since 1984 when it issued the unanimous decision in the Chevron case. But the court found that it now had discovered an inconsistency between Chevron and the Administrative Procedure Act. Moreover, the court says principles of stare decisis didn't justify retaining Chevron. First, because again, it was really, really wrong. And second, because the reliance interests here weren't actually all that meaningful. And you might wonder, how could that be the case, right? In a perhaps the most cited administrative law case of all time. But the court said, we've essentially been ignoring Chevron anyway since 2016. It hasn't appeared in any of our opinions. And the doctrine is really such a mess that no one could reasonably have been relying on Chevron deference. So there were some interesting concurrences in the case. Justice Thomas found that Chevron didn't just create an APA problem, it was actually inconsistent with Article 3 of the United States Constitution, which vests the judicial power in the federal courts. Justice Gorsuch wrote separately to say there's really no such thing as stare decisis. And then in a dissent, Justice Kagan made a positive case for administration. So reminding us why we have administrative agencies, what they do, including keeping the air and the water clean, reminding us what interpretive questions actually involve, and suggesting why it is helpful to have agency experts here. Now, it should be noted that the court in its decision didn't exactly say what will replace Chevron deference. So it It articulated, again, the standard from Skidmore, which is the standard that courts had used prior to Chevron to decide when to defer or when to incorporate an agency's views into its own interpretations. And so the court suggested that some cognizance of the agency's view about what statutory text means is still appropriate, but it's not clear exactly how the agency's view should factor into the court's own interpretation. They will be giving it some respect based on a handful of factors, including how long-standing the agency's interpretation is, whether it has shifted over time, perhaps how great the need is for expertise in a particular decision. But Justice Kagan's dissent is clearly concerned that will leave the courts as primary interpreters of statutes rather than agencies. There's also another interesting part of the majority opinion that should leave us sort of scratching our heads about whether things will change dramatically under Loper or less dramatically. And that is that the court emphasized that Congress can still indicate in particular statutes that an agency should receive more deference for its interpretations. It says that can be so where Congress says expressly that agencies should receive deference, but also where the statutory language merely implies agencies should receive more deference. So for example, the court says where the agency is just filling up the details of a statutory scheme, or where Congress uses terms that indicate agency flexibility. And it offers as an example the terms appropriate or reasonable. So if Congress says the agency gets to decide what is appropriate or reasonable in a given case, that could indicate that it wants the courts to defer more to agency interpretations. Some people think that that is an exception that will essentially return us to a Chevron-like space, because so many statutes do seem to delegate authority like that to agencies. I myself am a bit more skeptical. Some of those terms were used in Loper itself. We've seen the Supreme Court get quite involved in interpreting or reviewing agency interpretations of statutory phrases that involve terms like reasonable and appropriate. I'm thinking here of the Michigan versus EPA decision. So it remains to be seen what kind of implication this case will have, but many of us think that it will be something of a game changer in that agencies are no longer the primary interpreters of ambiguous statutory text. The court has assumed that role for itself. I want to talk about a case that came out shortly after Loper, which is Corner Post, which combined with Loper produces some weird alchemy. So Corner Post was an opinion by Justice Barrett. The plaintiffs in this case were a truck stop and convenience store in Watford City, North Dakota, so not an environmental case. They opened for business in 2018, and they accepted debit cards as a form of payment. And they are challenging a 2011 Federal Reserve Board regulation promulgated under the Dodd-Frank Act that set the maximum fees that merchants have to pay on each debit card transaction, called an interchange fee. A group of retailers had challenged this regulation when it came out. The DC Circuit had upheld it. Now Corner Post, which didn't even exist when the regulation was promulgated, brought an Administrative Procedure Act suit slightly different from the original suit, alleging that the regulation allows the charging of higher fees than the statute permits. Now, the trick here is that the relevant statute of limitations for challenging most agency actions appears in 28 U.S.C. section 2401, and it says suits are barred unless the complaint is filed within 6 years after the right of action first accrues. So the question in this case is, when does a right of action accrue? When the rule is issued, or alternatively, when the plaintiff claims to have been injured? And the Eighth Circuit affirmed the district court here in holding that a facial challenge accrues at the time the regulation is finalized. And because this rule was finalized in 2011, the court therefore concluded this challenge was barred by the statute of limitations. Now, this created a circuit split. At least 6 circuits agreed with the Eighth Circuit. Only the Sixth Circuit has found that the limitations period begins to run when the plaintiff is injured by agency action. But in this case, the Supreme Court agreed with the Sixth Circuit and found that the APA claim here does not accrue for purposes of the statute of limitations until the plaintiff is injured by final agency action. There was a lot of reference to dictionaries and the meaning of accrue in 1948. And today, reference to legal dictionaries that sort of accrue, an action accrues at the time of damage or loss. The court emphasized there's no special rule for administrative cases, and seems to require something like a clear statement before it would conclude that Congress meant anything else. The dissent thinks the court gets the statutory interpretation here flat wrong, goes through sort of the same justifications as the court's reading the dictionaries incorrectly, emphasizes that in the administrative law context, limitations provisions uniformly run from the moment of agency action. So this is going to create sort of a weird situation in which under this statute, 2401, there's essentially the opportunity to challenge agency rules on their face in perpetuity, right? Because any new entity can be created at any time after the rule is issued. And that will then give the new entity the opportunity to challenge the original rule, not in an enforcement action, right? Which has always been permissible beyond that 6-year period, but on its face. So this is an interesting case when we think about it in combination with the Loper-Bright decision, because if it gives entities new opportunities to challenge agency rules that we might have thought were long settled and beyond the limitations period, it now gives them the option to do that with Loper on the books instead of Chevron. Which means that the courts will have opportunity perhaps to revisit the interpretations of those statutes. Now, the court in Loper was careful to say not to expect a flood of challenges to old interpretations because of something called statutory stare decisis, which is a super strong deference rule that courts apply to interpretations of statutes. But I think it's far from clear whether that super strong stare decisis will hold in any individual case, and exactly what it entails. So there is at least the possibility that Loper, combined with corner post, will open the floodgates to challenges to interpretations of agency rules, not just recent agency rules, but agency rules that go back an awfully long time. The majority, of course, thinks that that concern is overblown. They point out that parties were always able to challenge agency rules in enforcement proceedings long after the rule was adopted. But if you look at the plaintiffs in corner post itself, they were never going to be able to challenge the rule in an enforcement proceeding because the rule wasn't directed at them, right? It was regulating banks and intermediaries and the credit card companies, not the entities that allowed debit cards to be used at their institutions. So it does provide more opportunity for challenge. Now, it bears saying, some environmental and energy law rules might be protected here from corner post because statutes might have their own limitations period. So again, this is only for rules that were promulgated under statutes where the relevant limitations period is in 28 USC, but the Clean Air Act, the Clean Water Act, RCRA, each have their own limitations periods, for example, although some people have queried whether the limitations periods in those statutes might be subject to reinterpretation by this court using the logic of corner post. All contain exceptions to the limitations period if grounds arise for a petition after the limitations period. So there is a lingering question there as well. The last case I want to talk about is SEC versus Jarkissi, another opinion taken by Chief Justice Roberts. And this case is about administrative adjudication. So the facts here that Mr. Jarkissi was the head of an investment fund. The Securities and Exchange Commission accused him of violating the anti-fraud provisions of security statutes by misleading investors. The SEC brought an action against him and chose to adjudicate it in-house, as is its option under the Dodd-Frank Act, seeking civil penalties. So the administrative law judge then recommended, and the SEC approved, a $300,000 civil penalty against Mr. Jarkissi, barred him from participating in the securities industry as well. Mr. Jarkissi then petitioned for judicial review, as one can do when one's case is adjudicated in-house at the agency, in the Fifth Circuit Court of Appeals, which vacated the SEC's order. And Mr. Jarkissi argued, and the Fifth Circuit agreed, that the agency's decision to adjudicate the claim in-house violated Mr. Jarkissi's right to a jury trial under the Seventh Amendment to the Constitution, which provides that in suits at common law, the right of trial by jury shall be preserved. Should also note here, the Fifth Circuit found that there were removal problems in the case. In other words, interference with the president's ability to remove executive branch officials, found there were violations of the non-delegation doctrine, but the Supreme Court granted cert on all three issues, but limited its opinion to the Seventh Amendment question. The Supreme Court here agreed that Mr. Jarkissi's jury trial right was violated. First, it found this was essentially a suit at common law. You might ask, how could that be, given that it was a suit brought under the securities statutes? But the court reasoned that the statutory fraud claims essentially replicated common law fraud actions. They did the same thing functionally. They used similar terms. The court also stressed that there were civil penalties involved in this case. And the civil penalties were designed to be punitive. The Supreme Court says that is a clear indication of a common law-like claim, whereas injunctive relief, declaratory relief would be more closely associated with equity claims. So the court finds this is essentially a suit at common law. And then second, that the exception allowing for public rights cases as opposed to private rights cases to be heard by agencies without a jury didn't apply here. And the court emphasizes that the test for whether something is a public right is historical. So the question is this the kind of case that historically could have been decided outside of the Article 3 courts? And while the court once again declined to definitively explain the distinction between public and private rights, it did find that given its decisions in other cases, this suit was more like a private right. Justice Gorsuch and Thomas, again, seemingly would have liked to go further in this case to suggest that administrative adjudication in general could actually be unconstitutional under the Due Process Clause, in part because administrative law judges are insufficiently independent, because the procedures in agency adjudication are less protective than what the federal courts provide. But this case did not go that far. It just held that in cases like Mr. Jarkissi's, that were essentially suits at common law and that did not qualify for a public rights exception, the plaintiff had the option of having that case adjudicated in the federal courts. Justice Sotomayor writes, the dissent in this case finds the decision flies in the face of precedent and historical tradition, cites the Supreme Court's own decisions in cases like Atlas Roofing that seem to state clearly that when the government has acted in its sovereign capacity to enforce a new statutory obligation, it may do so through the administrative process, whether or not it imposes civil fines or penalties. But the takeaways from this case are that agencies' ability to adjudicate claims in-house are now limited. It calls into question countless existing statutes that permit this. More than 24 agencies have this authority to adjudicate claims in-house. That includes the EPA, which can impose civil penalties under statutes like the Clean Water Act, the Clean Air Act, FIFRA. It means agencies may have to bring all of those actions in federal court if a litigant challenges the agency's authority to adjudicate them in-house. Some people have been concerned that this would produce a loss of expertise in deciding these cases, that it would impose an enormous administrative burden on courts. And so I really see this as part and parcel of a larger move, which I hope we'll have a chance to talk about in a few minutes, by this court to sort of chip away at some of the authority of administrative agencies that enhance the ability of the courts to decide some of these questions themselves. And before I turn it back to you, Jay, I just want to say briefly that if it wasn't all bad for agencies last term, there was one case, CFPB versus Consumer Financial Services Association, yet another challenge to the constitutionality of the Consumer Financial Protection Bureau, this time to the agency's funding structure, arguing that the funding of the agency through the Federal Reserve, which itself is funded through industry fees rather than through annual appropriations, was unconstitutional because it conflicted with Article 1's assignment to Congress of the power of government spending in the appropriations clause. The court seemed to make fairly short work of this one, said Congress decided the agency should be funded in this way, so it had done its appropriations duty. And this case would have created real problems for other agencies funded in whole or in part through industry fees, which include the Federal Energy Regulatory Commission, among others. This was a 7-2 opinion by Justice Thomas, with Justices Alito and Gorsuch in dissent. So a rare administrative law win these days, but I did want to mention that. Back to you, Jay.
End on an up note there. Well, thanks, Sharon. That is a vast amount of ground covered in a concise fashion. We will circle back to some of these administrative law issues. They are not going away. They'll be in the preview as well. At the moment, though, I just want to tackle a couple of questions in the queue that seem to have sort of smaller practical implications. Some of these decisions might be good to address now. I'll take on one subject, Sharon, to your correcting me if I get it wrong, and then there's another one I'd like to throw back to you. One question asks whether LOPR will have effect on judicial review under statutes other than the APA, the broad APA review provisions. My take is no, or at least not for the moment, that in the same way as corner post should not affect environmental statutes that have their own statute of limitations, statute of repose that supersedes what's in the APA. There are also in some and rare environmental statutes that don't necessarily route through the APA, but provide their own standard of review for certain sorts of agency actions. One example I can think of is just last week, there was a district judge who decided a Tosca case holding that fluoridation of water, public water supplies, hits a threshold that should trigger EPA review and regulatory action. And there, I think the judge was citing a Tosca provision that called for de novo review by the judge when it hits the court. So that's my take on that. Correct me if I'm wrong, Sharon, but then the question for you is the one above that, people asking about the interaction of the death of Chevron deference with other forms of deference, Auer and Skidmore deference. And certainly Robert cites to Skidmore, the 1946 case that was also in the mix when the APA first came about and set some standards for judicial review. I'd put the question a little differently. Is there enough there, either in the court's opinion, Skidmore itself, the history of Skidmore case law, is there enough to really provide signposts going forward for what judges should now do when they look at these agency actions, or is that to be decided?
So I would say it's TBD. First of all, I agree with you in your response about standards of review and other statutes. The majority opinion certainly leaves open the possibility that Congress can specify a standard of review that looks much more like Chevron if it wants to. Now, the concurrence, right, which is skeptical of Chevron's form of deference under the Constitution, would not agree, but there doesn't appear to be a majority for that proposition. With respect to, what is the standard going forward? How do we understand what courts are meant to do now? Is it Skidmore? Is it something else? Is our deference on the line? So, the court did cite to Skidmore with apparent approval, but didn't lay out sort of the set of factors that courts should be using to decide whether and how much deference to give to agency interpretation. So I think this is an issue we're going to see worked out case by case in the lower courts that will undoubtedly percolate back up to the Supreme Court at some point. I mean, one of the justifications that the court gave for overruling Chevron was that the doctrine had become unworkable, that it was just too difficult for lower courts to figure out and apply, and what all the exceptions were. I think the court has actually created a similar problem under LOPR. This is, it's something that lower courts will have to wrestle with. There will be some courts, I think, that sort of adopt a Skidmore approach, and that's not obviously wrong. It's also not obviously required by the Supreme Court's decision, which seemed to emphasize much more factors like how consistent has the agency been over time in its interpretation? How close in time was the agency decision to the promulgation of the original statute? So I think we'll see some courts going a Skidmore direction. I think we'll see other courts kind of doing this on their own with relatively little deference to agencies, and we'll really have to wait and see how the Supreme Court ultimately resolves that question. And we'll say the Auer deference piece is a little bit different. So Auer is a doctrine that requires courts to defer to essentially reasonable agency interpretations of their own regulations. That was preserved in a case called Kaiser versus Wilkie a couple of years ago in an opinion by Justice Kagan, albeit with lots of qualifiers about when Kaiser would apply. It's certainly possible the Supreme Court will take an opportunity to revisit our deference in the coming years under the logic of Loper, but we'll have to wait and see.
Well, thanks, Sharon. And I just add that in response to that question, I've been pointing out that in Loper-Bright itself, the court didn't even resolve the Magnuson-Stevens issue in front of it. They didn't take that question up on cert. They didn't really wrestle with the facts or the holdings of that case, and ended up remanding the Loper-Bright and Relentless cases back to the DC and First Circuit. So maybe one of the first signposts we're going to get, because there is litigation in those circuits to sort of the trailing litigation to resolve those cases, how those courts behave might tell us something about what this looks like going forward. We need to move on to some other issues and cases. Next up, Gerald is going to talk about Texas versus New Mexico, which is a case invoking the court's original jurisdiction on water rights.
Well, I'm not sure this will be quite as interesting as Sharon's presentation.
Our original jurisdiction is a hot thing right now. We may get to that too.
Well, we may get to that, but the genesis of the decision I'm going to talk about actually arises in the majority opinion by Gorsuch in the case in which the ability of the United States to participate in this at all was raised and was essentially affirmed below. And one of the questions when you look at the Texas against New Mexico case that was decided is to what extent did that previous case actually resolve for the justices what the issue was in front of them. So the issue is fairly plain. In the West, as virtually everyone knows, the regulation of interstate watercourses is complex. The West is dry. The states are all competing for various quantities of water. Typically, when the states disagree, the compacting provision that the Constitution provides is the method through which these disputes are resolved. Texas was suing New Mexico, challenging its performance under the existing compact, and suggested that some of the diversions that New Mexico had made puts in jeopardy the obligations of Colorado and New Mexico to contribute the decided upon amounts of water to Texas. The United States intervened in a series of claims that were parallel to those in Texas. And then the question initially was, could the United States intervene? The answer was yes. And then it was referred to a special master who produced a 151-page opinion concerning the dispute. New Mexico and Texas essentially settled based on the special master's decision, and the United States challenged. The United States said, because the United States has claims that the parties that New Mexico and Texas couldn't settle in a way that would eliminate the claims, the valid claims that the United States had in front of it. So the question that divided the court, and it was a 5-4 decision, Justice Jackson writing the opinion for the majority, Gorsuch, Thomas Alito, and Barrett dissenting. The question was whether the settlement ought to be approved, and whether the United States then could pursue its claims, the remaining claims that it might have, in other federal fora. The argument that Justice Gorsuch made in the dissent, and I'll start with the dissent and then come back to the majority, was that in many ways the claims of the United States were parasitic on the claims raised by Texas, so that if Texas was then satisfied, there's no reason to permit the United States to pursue claims that are otherwise resolved. Now, the issues for the United States it's complex, but they're relatively straightforward. One is how do they guarantee that there'll be sufficient water to satisfy contracts that the United States has to conform to, one, and whether there would be sufficient water in order for the United States to comply with treaty obligations with Mexico. So there are, clearly issues that are related to the federal government. And what the majority said was that the settlement that was agreed to between New Mexico and Texas, it wasn't clear that the settlement would give the United States the capacity to feel confident that the obligations that it had undertaken were able to be satisfied. Now, let me lay out a little bit of the facts. The water, which is from the Rio Grande, which is to be accessible to Texas, was essentially going to be regulated by first the creation of the Elephant Butte Dam and the reservoir, and the delivery of water to that reservoir, which would then be used to satisfy the claims that were incumbent on the United States. The Elephant Butte Reservoir is 110 miles from the Texas border, right? So the water still has to get from there to Texas. The problem that Texas raised was that the conditions had changed dramatically between the 1938 compacting process and today. And it had changed in this way, that when the initial dispute arose, there was not very much groundwater extraction. And so if New Mexico permitted the rate of groundwater extraction that it currently did, the capacity to satisfy the amount of water that was left in the river, given the relationship between groundwater and the surface water, would put in jeopardy the agreement that they then needed to satisfy the claims of Texas. So the one way to think about it was, what's the baseline for determining what how the compact ought to be assessed? Is it 1938 when there was no groundwater extraction, or can it be based on the formula that the United States had adopted in the interim to determine whether there was sufficient water to satisfy its contracts and its obligations, its treaty obligations? And it was complicated because the measurement of the water would be done at a federal gauge in El Paso, so at the border. So the question was, well, or the question for the dissent, and the one that the majority had to address, is if there's sufficient, if the United States already has a process for measuring and accounting for the water that is going to be transferred to or made available to Texas, and it measures the amount of water at this gauge in El Paso, isn't that sufficient to satisfy the claims of the United States? The United States said no, they're not. And the reason they're not is the accommodations that were reached in the compact wouldn't be a sufficient guarantee that the United States would have enough water to take from Elephant Butte to satisfy those claims. And so the question was, should the settlement be approved? And the majority of the court said no. That the objection by the United States were sufficient. The objections were sufficient to lead the court to deny the approval of the settlement, because if the settlement were approved, the capacity of the United States to pursue those claims within this particular litigation would be at an end. So the way the court framed it was, can two parties to the suit settle the case in a way that eliminates the claims of another party? Right? And they said no. So the issue will go back down to be renegotiated, and presumably it'll be renegotiated in a way that satisfies the United States that it will be in a position to meet the obligations under both the contracts and the treaty. The dissent, you could almost feel them shaking their heads when you read it, because they were saying, wait a minute, the federal government has already approved this formula, and now you're giving them a chance to redo the formula or to potentially put restrictions on what New Mexico can do in order to satisfy the obligations of the contract. New Mexico raised the claim that if you restrict groundwater extraction or restrict it substantially, you're not just restricting the amount of water under state law that New Mexico can get, but you're also putting in jeopardy a huge segment of their economy, right? So they framed it in terms of the economic distress that New Mexico might be put in place, and in terms that are plain to everyone, and in fact clear, that water law is state law, and that the failure to approve the compact would in effect permit interventions in rules that the state would have generated for itself. So that's essentially where the case lies. The question that the dissent and the majority didn't directly engage was whether going forward this is appropriate for the original jurisdiction that triggered the initial litigation, because the parties who could trigger original jurisdiction basically wanted out of the suit, right? And I think that's one of the things that bothered the dissent in particular. So the role of the United States in these interstate compacts, especially, and there are several of them in the West, right? We faced one last term, right, in relationship to the Navajo Nation, right? But the federal government's interest is distinct, even though it's parallel to the interest of Texas. And one of the things the majority was making clear is once they granted them the right to intervene, that right could not be eliminated by the other parties, basically. And that's essentially where the case rests. The special master will have to reconsider the claims of the United States, and they'll have to be, I think, articulated with sufficient specificity to be able to maintain the distinctiveness of the federal claims in that litigation. I don't know if that was sufficient, but that's my view of the case. You know, these ought to be put in the long line of cases between New Mexico and Texas, right? Whether it's the Pecos, whether it's the Rio Grande, you know, the relationship between Texas and New Mexico over water is absolutely fraught. And the advent of the groundwater extraction, which wasn't an issue initially, actually has a potentially significant impact on the continued relationship between Texas and New Mexico, because it will affect the amount of water that flows from New Mexico to Texas. So,
Gerald, what was the alignment of justices in the majority and dissent? Is there
Jackson,
anything to be gleaned
Roberts,
from that?
Sotomayor, Kagan, and Kavanaugh were the majority. So you know, it was you know, it didn't break up on the liberal conservative axis that people often think about this court, right? One of the way, I think, if I were going to break it up that way, so it was Gorsuch, Thomas, Alito, and Barrett in the dissent, and part of it was I think if you look at both opinions, it is about federalism in some ways, right? Although not explicitly, and it's about the power of the federal government to intervene in things that everyone concedes ought to be resolved by state law, by and large. The problem, of course, is the United States did have specific obligations that were unique to the federal government. Now, Justice Gorsuch in the dissent, right, said that that there was no allegation that there would be insufficient water in the settlement for the United States to satisfy its treaty obligations to Mexico, or to satisfy the contracts that it was subject to fulfilling. But if the United States, the view was that if the United States, the majority anyways, if the United States felt like the master's decision didn't give sufficient protection for the United States to address those specific claims, well, maybe they ought to be permitted to revisit the agreement, and they shouldn't be excluded from the case by two other parties. Now, the thing that I think that you do kind of have to take seriously, and it was a tension between the majority and the dissent, was the claim that this actually doesn't harm the federal government, because the federal government can pursue the claims, if they're not just parasitic on the claims of Texas, in a federal court, other lower federal courts. One might wonder why you would want to do that if, in fact, merely revisiting the decision of the special master, right, could directly address these solutions without then necessitating additional litigation. And now, no one talked about judicial economy, right? But the way when I was reading, that's the thing that came up for me. It was just, look, this, if you exclude the United States from this case, what you're doing is you're merely setting up a series of additional pieces of litigation. And they've gotten it to a point where they probably can push it to get the agreement they need, so that the United States is satisfied that it can meet its obligations And it doesn't make sense to permit two parties to exclude a third party where that third party still has interests that are live and not satisfied by the settlement agreement itself. And so I think that's where I would, that's how I view that, the opinion. You know, the breakdown really did, and the reason I started with the 2018 opinion, right, really does break down over what the United States can assert, right? And if you read the 2018 opinion, right, where a unanimous court, opinion written by Justice Gorsuch, where he clearly permits the United States to intervene in this proceeding because of the interest the United States has. What the dissent was suggesting is that when you read the 151-page special master's report, the United States ought to be satisfied with the result that's reached. And if they're not, they can pursue additional litigation. But it strikes me that the question of whether the special master's report actually satisfied the claims the federal government had, the parties ought to actually engage in that, as opposed to someone who wasn't a party to the actual negotiation being able to assert that their interests are satisfied. Now, maybe that's too practical, I don't know. But it seems to me that that would be the most straightforward approach. And I think that's what Justice Jackson was asserting in her majority opinion.
Thanks, Joe. Over to Bob. No Supreme Court term would be complete without a takings case or two.
Right. I'm going to talk about two takings cases the court decided last year, as well as a Clean Air Act case decided supposedly as an emergency motion. There was a big shift in the court's takings jurisprudence when Justice Kennedy retired in 2018. He truly had been the person in the middle. My analysis of his votes in takings cases showed that he had been in the majority in all 10 regulatory takings cases that had been decided when he was on the court. Now, with the change in membership of the court, instead of having Kennedy in the middle, who voted about half the time for the property owner and half the time for the government, the property owner almost always wins. But the two takings cases actually were unanimous. In Sheets versus County of El Dorado, the question was a regulatory exaction. The court developed its regulatory exaction doctrine starting in the Nolan versus California Coastal Council case in the 1970s, where it said that if you're going to ask a property owner to dedicate an easement to the government as a condition of getting a variance from existing zoning regulations, there has to be an essential nexus between the environmental impact of the development and what you're asking for the easement. And then subsequently in Dolan versus City of Tigard, the court said not only does there have to be an essential nexus, but it's got to be roughly proportional to the impact of the development. And in the Sheets case, the county had regulations that required development impact fees on developers depending upon the size of their project. Sheets was asked to pay $23,420 because of the size of his development. And he said, no, you needed to do an individualized assessment of the proportionality of the impact of my development. In court below, the county successfully argued that this is not a situation where there's a negotiation between the developer and the county. The fees are done and set by the county council, and therefore you don't need to do the individualized assessment. And the Supreme Court unanimously reversed that in an opinion by Justice Barrett. Now, what was interesting about this is there was a debate about whether this was even a takings. taking. In fact, Justice Sotomayor, in a concurring opinion joined by Justice Jackson, said, the court never holds that this is even a taking. All we hold is that it was wrong to say automatically, if it's set by the legislature, you don't need to do an individualized assessment. And in a concurring opinion by Justice Kavanaugh, who was joined by Justices Kagan and Jackson, Kavanaugh suggested that in cases where whole classes of developments are going to be affected by these county mandated fees, maybe you don't have to do such an individualized assessment as you would in other cases. In the De Valera case, De Valera versus Texas, the state of Texas had decided to build a 3-foot barrier between the lanes of Interstate 10 in order to prevent a complete flooding after major storms of both parts of the interstate, so that at least there could be an evacuation lane maintained. But that foreseeably caused extreme flooding of lots of farms in the area because it kept the water from just traveling over the whole interstate. And De Valera and some of the other farmers sued and said this was a taking because it was foreseeable that the result of this government action was going to be to flood my property. The state of Texas removed the case from state court, brought it to the federal courts, and then said, voila, now that we're in federal court, there's no specific federal cause of action to recover compensation for a taking, and therefore the case has to be dismissed, and the Fifth Circuit so held. But when the case got to the Supreme Court, oral argument was really important because all the justices thought this is horribly unfair. These people have had their property flooded by deliberate government action, and you're essentially saying because of this clever trick in removing the case to federal courts, you have no right of action. So they basically bludgeoned counsel for Texas into conceding that the plaintiffs should be able to refile their case in state court. Now, this might actually have some implications for the climate litigation because that's exactly what the fossil fuel industry is trying to do to the counties, cities, and states that are suing them in state court. They're saying all these cases belong in federal court, and then voila, because of the decision in the American Electric Power case in 2011, the Clean Air Act displaces the federal common law of nuisance, which should govern this all. None of the lower courts have really bought that at all, but we'll talk about the climate litigation a bit later. So this was a unanimous decision written by Justice Thomas. Now, the third case, Ohio versus EPA, had a really strange procedural posture. It involved EPA's good neighbor rules under the Clean Air Act. Since the beginning, the Clean Air Act has said that state implementation plans have to include provisions to prevent an upwind state from significantly interfering with the ability of downwind states to meet the national ambient air quality standards. EPA really implemented this quite belatedly in the waning days of the Clinton administration, and its first effort to require states to revise their SIPs in response to petitions from downwind states resulted in EPA adopting a very novel rule that said we're going to define significant contribution based on what could be done at a fairly low cost. That initially was upheld by the DC Circuit, but later, in an opinion by Judge Kavanaugh when he was on the DC Circuit, he rejected EPA's good neighbor rules and had the grounds for that rejection being, oh, it's possible some upwind states might have to over control, and the Fed should have given the states 3 more years. That was then appealed to the Supreme Court, and in the court's 2016 EME Homer decision, Judge Kavanaugh's decision was reversed by a 6-2 majority of the justices, saying the act doesn't require such hyper-technical calculations, and the good neighbor policy of EPA should go into effect. Now, in its latest iteration of the good neighbor rules, a number of states went to the Supreme Court on an emergency basis. The rules actually were enacted well over a year before the court's actual decision, but they said all these horrible things are going to happen right now, even though the compliance deadline is years away. And so you should treat this as an emergency motion. They made that motion in October of last year. The court sat on it until February when it decided to hear oral argument, which was a real, I guess, positive development with respect to how they deal with some of these emergency motions after having, without any oral argument, stayed the Clean Power Plan in 2016. And many people, myself included, thought, aha, this is Justice Kavanaugh's revenge for the fact that the court had reversed him before in EME Homer. He didn't end up actually writing the majority opinion, Justice Gorsuch did, but the court's rationale for granting a stay of the good neighbor rule was that some courts of appeals in other parts of the country had granted stays, and therefore this plan, which was supposed to apply to 23 states, now only applied to like 12 of them. And so EPA said, but that's crazy because our calculations for the states where the plan wasn't stayed are not affected at all by the fact that other appellate courts have temporarily stayed the rule. And what was interesting about this case is Justice Barrett wrote the dissent, joined by the other 3 female justices on the court. So you had an all-female dissent with Barrett saying, this is kind of ridiculous to say there's likelihood of success on the merits just because some other courts stayed this. As a result of this decision, the court this summer was flooded with emergency motions to stay other EPA rules, even before challenges to them were heard by the lower courts, and even though the lower courts had unanimously denied stays of those rules. It was almost like, I was quoted in the New Republic last week as saying, it's like industry groups now think no EPA rule can go into effect unless the Supreme Court has explicitly approved it. They did last Friday dismiss the applications for emergency stays of the methane rule and the mercury and air toxics rule. They're still sitting on motions for the greenhouse gas rule that industry petitioners want stayed. But the court brought that upon themselves by inviting all these emergency applications, given its willingness to stay the good neighbor rule. Now, so that kind of wraps up last year's term. What's happening this year? Well, the first environmental case will be argued a week from today, and it's San Francisco versus EPA, a Clean Water Act case. And this is a case that I think most observers, including the petitioners, were surprised that EPA granted towards the end of last term. It's a case where San Francisco is challenging its permits for combined sewer overflow outfalls into the Pacific Ocean. Under the Clean Water Act, the permit that EPA and the state jointly issued to San Francisco specified that they should not be polluting at levels that would interfere with the water quality standards of the receiving waters. And the petitioners are saying, well, that's an impossible standard for us to meet because we don't always know what water quality will be in the receiving waters. Now, EPA argues that from the very start, the text of the Clean Water Act says that we can impose effluent limits and other limitations. And since the purpose of the act is to protect the water quality in the receiving waters, it only stands to reason, and we've been doing this for decades and decades, that we should be able to include in those permits a term that they have to ensure that the receiving waters don't violate water quality standards. Given that the court has been so hostile towards EPA and environmental regulations generally, and the fact that they granted this case, which no one really expected them to do, I don't think it portends very well. One other thing I want to mention about the court's October 16th sitting is that the first case they will hear that day, it's a Veterans Administration case called Bufkin versus McDonough, but it raises one of the issues that Sharon mentioned, in that there's a statute that says when in doubt, give the benefit of the doubt in interpreting a statute to the veteran. And they're going to see what the implications are that in a post-Loper-Bright world.
Thanks, Bob. And I just point out that the San Francisco case may itself turn out to be an example of what a review of agency action looks like in a post-Loper-Bright world. I can't recall whether in the early stages EPA was invoking Chevron deference there prior to the decision, but certainly in recent briefs, both sides, I think, are latching onto Robert's language, suggesting that contemporary and consistent interpretations of a statute may be given additional weight, and both are sort of claiming that for their view of the Clean Water Act. Thanks also for turning us to our preview segment. We're into our last half hour. My understanding is we can have a few extra minutes, audience willing, if we need them. But I want to keep moving forward to the current grants. I'm counting at least 3 other petitions we know of that have been granted for the upcoming term. So let's go first to Gerald for the court's first major NEPA case in 20 years, but then I also want to circle back to Sharon on the administrative law front. So over to you, Gerald.
Well, you know, as someone who, in a fit of a masochism, I suppose, has read every single NEPA decision ever decided. This one, you know, this one is a significant challenge, right? Because what it really does, what the case is, 7 counties infrastructure coalition against Eagle County. So Eagle County is the case. And one of the question that's presented is, what can an agency consider in its evaluation of the environmental impacts of a decision? And one of the ways that it's one of the frames to limit agency consideration is whether it can only consider those effects that it has administrative authority or legal authority to regulate. And of course, the challenge is whether when it's considering permitting a particular decision, whether it can consider all of the environmental implications of the granting of the decision, even if they're environmental implications that are not strictly within the capacity of the particular agency to regulate. I would ask my fellow panelists to opine on how the court's going to decide that. You know, it will significantly restrict the range of issues that an agency is permitted to take into account, and it raises the potential for challenges to an agency decision where the claim can be made that the environmental impact assessment, the environmental impact statement, the environmental impact judgment was predicated on things over which the agency has no jurisdictional reach. So I'm not venturing a prediction on this. I would leave it to Bob or to Sharon, who are better prognosticators, I think, than me as to this. The case I saw the case is it's called Eagle County, is the way I'm referring to it.
Gerald, isn't it the case that in all 17 cases, NEPA cases, the Supreme Court has decided the environmental side of the case is always lost? So I think
well, yes.
And not only that, but they've gotten almost no votes.
I'm sorry, what?
Oh, not only that, but they've received almost no votes from sitting members of the Supreme Court.
Right. So, one of the interesting things about NEPA, of course, right? And I mean, for those of you who are old enough to remember when it first became law, right, was the question of there being essentially no substantive law in NEPA, right? And a lot of environmentalists initially were skeptical of NEPA's capacity to produce the kind of environmental improvements that the drafters of the statute anticipated. But what has happened historically is it has actually improved the environmental decision-making of agencies. And what this challenge, right, is a challenge to the capacity of agencies to consider broadly the environmental effects of a particular decision. And which means that even though NEPA really has been a success to the extent that it has improved environmental decision-making, this is a direct challenge to that trajectory, I think. And that's what's most concerning.
And I don't disagree with anything Gerald has said or those predictions. I just want to point out there are permitting cases in particular that involve the Federal Energy Regulatory Commission, permitting natural gas pipelines and export terminals, where it is part of the agency's duty in analyzing the application to take environmental impacts into account under something like a broad public interest standard, for example. So, in those cases, it is the agency's responsibility to determine environmental impacts. So we might not see a decision in this case extending to those cases.
Right. I mean, I completely agree with you. A lot will depend, of course, on the language that's chosen to resolve the issue. As Bob was pointing out in his discussion, right? The characterization of the issue by the court is going to be absolutely critical. But I agree with you. Where there are substantives, where you can point to the underlying statute requiring the agency to do X, Y, or Z, right? Then I think the agencies will continue to have sufficient latitude, or they will exercise that latitude with some care, but they will still have the latitude to act.
Thanks all. Sharon, you mentioned FERC, so that automatically turns things back over to you. What other kinds of lateral cases are coming in that could clearly affect environmental decision-making as well as other sorts of agency decision-making?
So a case that I wanted to talk about that has now been granted for next term is NRC versus Texas. So it was just granted on October 3rd. And this is an important energy environmental law decision, but also raises an important administrative law question. So this is a case about the siting of nuclear waste. And the backstory here is that spent nuclear fuel from reactors has been building up in storage on site at the reactors themselves because the federal government has failed to create a long-term depository for that nuclear waste as it is required to do by statute. The site it had chosen was Yucca Mountain in Nevada, but due to political pushback and for other reasons, it is no longer moving forward with that site as a potential repository. So the question is becoming, what do we do with all of this nuclear fuel that is piling up on site at reactors? And here, the Nuclear Regulatory Commission, in this case, granted a license to interim storage partners to store some of that high-level waste at a site in Andrews County, Texas, which is in the Permian Basin, where there's a lot of oil and gas extraction happening. It granted that license in 2021 to store nuclear fuel for 40 years, renewable up to an additional 40 years. So this is nothing like the long-term storage we were expecting from Yucca Mountain. It's an interim measure, but the state of Texas challenged the license, as well as mineral rights holders in West Texas. And they argued that the Nuclear Regulatory Commission does not have the authority under any of its statutes, including the Atomic Energy Act, to license this kind of privately owned away from reactor storage facility for spent nuclear fuel. And the Fifth Circuit ultimately agreed with that challenge and vacated the license. Again, this is a statutory interpretation question involving sort of really in-depth parsing of the language of the Atomic Energy Act, the Nuclear Waste Policy Act, neither of which explicitly grants authority to site this kind of storage facility, but both of which contain kind of broad delegations of authority that could be construed as authorizing this type of licensing. There's a circuit split in this case because the 10th Circuit and the DC Circuit have come out the other way on the licensing authority for this type of facility. The DC Circuit, in an opinion by Judge Rao and Judge Walker also on the panel, right? So there we have in the Beyond Nuclear case just a fundamental disagreement with what the Fifth Circuit has decided. The Supreme Court granted cert on this interpretive question, but also on an administrative law point, which is whether the Hobbs Administrative Orders Review Act, which is sometimes known as the Other Hobbs Act, not the criminal statute, authorizes a party aggrieved. The statute authorizes a party aggrieved by an agency's final order to petition for review. But there's a question about whether or not Texas and the mineral rights holders were parties aggrieved in this action because they sought intervention before the agency, but those petitions were denied. So they were not parties in kind of the traditional sense, other than they had tried to intervene and failed. The Fifth Circuit has this special exception where it says if someone is challenging an agency's action as beyond the agency's authority, in other words, as ultra virus, then they can still bring a challenge under the Hobbs Act, even if they weren't a party. And so that is the claim here, right? That the Nuclear Regulatory Commission did not have the authority to grant these licenses. And that's why the Fifth Circuit found they could still bring this challenge. So it's possible the Supreme Court took this case simply to resolve that threshold question about who may challenge agency actions. If they resolve it in favor of Texas and the mineral rights holders, that will, again, sort of expand the number of challenges we can expect to see to agency actions for agencies that are covered by the Hobbs Act, which includes sort of a smaller set of agencies, but it includes the Federal Energy Regulatory Commission, the Departments of Agriculture and Transportation. The court might also reach the merits and tell us whether we have a Nuclear Regulatory Commission that can deal with this problem of accumulating nuclear waste under its statutory authority. So stay tuned. I'm looking at the time. There's one other brief case I wanted to mention. Maybe I'll discuss in like 2 minutes.
It's worthwhile, yeah.
Which is the Supreme Court also granted cert in a case called Wages and White Lion versus FDA, which is actually a case about tobacco products and the FDA's denial of approval for flavored e-cigarette products under the Family Smoking Prevention and Tobacco Control Act. These are products that have fun names like Hawaii Colada and Margarita Mixer and Mandarin Mint, right? And so a huge number of applications were submitted to start selling and marketing these products. FDA issued guidance documents about what had to be submitted as part of those applications, what kinds of studies, what kinds of data it needed, and then ultimately just denied all of the applications. So the e-cigarette companies challenged that denial, basically saying it was arbitrary and capricious under the Administrative Procedure Act because, among other things, they kind of had no notice of the basis on which their applications would be denied, that they were told to submit things that the agency never ultimately considered. And the Fifth Circuit agreed with them. So this is a case that, again, sort of back to Bob's discussion of Ohio versus EPA, seems to take quite an intrusive approach to judicial review of agency action under the arbitrary and capricious standard, requiring sort of quite a lot of agencies. You know, the Fifth Circuit seeming to say, or they did say, I just found this an amazing quote, it was the regulatory equivalent of Romeo sending Mercutio on a wild goose chase and then admitting there was never a goose while denying he even suggested the chase. Right. So the Fifth Circuit view is that this was a real bait and switch on behalf of the agency that didn't provide the applicants fair notice of what the agency's review process was going to look like. You know, it should be noted, and the dissent does note in the Fifth Circuit case, that there's nothing like a guarantee that the FDA issued anywhere that these applications would be approved, right? And the statutory standard for approving or disapproving the applications remained the same throughout, right? The agency was trying to balance the beneficial effects of granting these petitions on people quitting smoking against the potential harm, especially to young people who might start using tobacco products for the first time. This could be a case of the Supreme Court granting cert in a Fifth Circuit decision just to overturn it. Some people have said that the court might like to do this because it makes it seem balanced and reasonable on administrative law questions. Like, let's take a really bad decision from the Fifth Circuit, like the CFPB case from this past term, and overturn it to show that, like, we're quite middle of the road on administrative law questions. I don't know if that has any basis to it whatsoever. I personally hope that they reverse the Fifth Circuit. I think this is a pretty bad decision that would open up agency denials of applications to much, much greater scrutiny and require an enormous amount of data and explanation from agencies in a way that could actually result in agencies providing less guidance on how they're going to review applications. Because the more guidance they provide, the greater the chance they'll be accused of some kind of bait and switch later. And I don't think that is to anyone's advantage.
Thanks, Sharon. That gets us through actually all the way the current grants and the upcoming term. But there are a number of pending petitions that are fully briefed and up for decision by the court. Some possibly as soon as this Friday's conference. I want to at least touch on that pool as well. And Bob, maybe back to you. You pointed out earlier, you mentioned climate litigation. One theme that's sort of unifying a lot of these petitions to the court is climate cases, whether challenges to federal agency action or to state climate litigation. Could you brief us on some of those, what might be bubbling up shortly?
Yeah, well, all the federal courts have upheld the remanding of efforts to remove the state climate litigation to federal court. And in fact, on April 1st, 2023, the Supreme Court denied cert in all these cases where the industry groups are saying this case must be heard in federal court. But then there's always additional litigation, and they later, last term in January, denied an effort to bring a Minnesota case where it was remanded to state court before them. And now the case that the court has before it is the case involving Sunoco versus Hawaii, where the Hawaii Supreme Court said that state climate litigation could go forward. What's happening in these cases, the fossil fuel industry desperately wants to avoid any trial that would reveal their disinformation campaign and their efforts to try to confuse consumers about climate litigation. The basic argument that's being made by the fossil fuel industry is that because climate change is a global problem, it can only be dealt with by the federal common law of nuisance, which the Supreme Court had held in American Electric Power was displaced. Now, this is really trying hard to turn apples into oranges, because the American Electric Power case was a federal common law case brought in federal court to start asking for the federal courts to come up with a grand plan to reduce emissions of greenhouse gases. all of these state court cases are basically consumer fraud cases, saying that like the tobacco industry, the fossil fuel industry should have to pay for its fraud and disinformation campaign and give us damages under state law. These are not federal cases. There's no way the federal common law of nuisance would apply to them, and yet they rely almost entirely on a single decision by a Second Circuit panel several years ago, where another federal common law case brought in federal court asking for the courts to fashion a plan to reduce emissions was dismissed, and you got the judge to opine. And by the way, I think all climate litigation should be preempted by the federal common law of nuisance. On June 10th of this year, the Supreme Court in the Hawaii case called for the views of the Solicitor General. And there's also another original case filed by Alabama and a bunch of red states against 5 blue states where climate litigation is going on in state court, asking the Supreme Court to intervene and quash all climate litigation. Now, the grounds for doing that using the court's original jurisdiction are incredibly vague. It would be sort of the ultimate power grab. And in fact, when the Baltimore case was before the court in 2021, where the question was, what standard do you use? How many grounds can you consider in reviewing decisions to remand cases back to state court? Justice Barrett said it would be awfully aggressive of us to go and do what the oil industry wants. Now, this has actually led to a major coordinated campaign that includes like TV ads that are going out and ads on social media. Supreme Court, please take the case. That's like Leonard Leo's network wants to signal the conservative justices, this is really important to us, you must do that. But it would be breathtakingly overreaching by the court to stomp on principles of federalism that it's been pretty consistent with preserving.
Yep. Bob, I was going to say that'd be an outrageous extension of original jurisdiction in the case that you just said.
Yeah, and when Colorado legalized pot, then Oklahoma Attorney General Scott Pruitt tried to file an original action saying this is going to lead to more people in Oklahoma having pot illegally, and therefore they're creating a nuisance. That was dismissed quite quickly. Now, the fact that they asked for the views of the Solicitor General just last week on the Alabama original suit, I don't think that's of great significance. When I was clerking on the court, that was kind of a routine way of ducking a case and buying more time. They didn't give the Solicitor General any deadline. It usually takes about 6 months before you'll get such a brief. But what will be interesting is the Trump administration had previously supported the fossil fuel industry. So it may be they want to get the Biden administration on record as, having changed the federal government's position on that.
But it's nonetheless a clear trend, though. I mean, earlier, Bob, you mentioned one trend that's mushroomed is emergency or extraordinary petitions to the court. It was an earthquake in 2016 when the court stayed the original power plan. Now it's become routine. And similarly to these original jurisdiction filings, in addition to the Alabama case, I could point to Utah has filed against the United States, claiming essentially mismanagement of federal public lands, or that the lands ought to revert to the state, and that's an original jurisdiction petition for the court. There was a previous denial earlier this year. Alaska had sued over the Pebble Mine case. It kind of done an end round around the traditional APA challenge and filed directly to the court, claiming that the U.S. was trumping its sovereignty by EPA's veto of the Pebble Mine permit. That was denied, and then Alaska has since gone back through more traditional litigation channels. But these filings have cropped up, and that seems to be a trend as well, at least until there's a clear statement that the court is not interested. Couple other things out there. I don't know who wants to touch on them. I would just note other petitions that I believe are up this week are a couple against EPA and the California waiver challenging challenging California's waiver authority under the Clean Air Act. A couple consolidated cases from industry in the states led by the state of Ohio. I think that's up for decision on Friday, or potentially later this term. Sharon, you're also tracking a Consumer Product Safety Commission petition that I think is maybe ripe for the court to decide.
Yeah, I mean, very quickly on the Consumer Research versus CPSC case, again, out of the Fifth Circuit, it's just sort of case, if the Supreme Court grants it, really tees up the question of like, how much further does the court want to go in changing the approach to administrative agencies? And this is a case asking whether or not the court should overturn its own precedent in a case called Humphrey's Executor that upheld the constitutionality of multi-member independent commissions like FERC, commissions like the Nuclear Regulatory Commission, or instead whether all of those commissioners must serve at the pleasure of the president. So even though the challenge is to the Consumer Product Safety Commission, this is a decision that if the court takes up the case and if it decides that these agencies are unconstitutional, could cause real upheaval in administration.
Thanks, Sharon. Well, we're at the end of our time. I think I will call it here. That does take us through at least the current and near-term docket. So I appreciate your willingness to wedge all that in, the audience's willingness to listen to it all. It's a lot to take in, but it's very, very expertly done. Sharon, I also appreciate your diligence in answering some of the questions in the Q&A queue. I feel our ability to integrate that into the discussion rather than separate Q&A period was helpful, and the multitasking sometimes works. So thanks for that. And Madison, I'll turn it back to you for a wrap up.
With that, our 2024 annual Supreme Court review and preview comes to a close. Thank you so much to Jay for moderating, as well as to Sharon, Gerald, and Bob for providing their expert commentary again this year. We so appreciate all of you taking the time out of your extremely busy schedules to make this program happen. Thank you as well to our audience for joining us and for your great questions. If you missed any part of today's webinar, the recording will be available on the event webpage within a few business days. If you enjoyed today's webinar, we encourage you to check out ELI membership to gain full access to all of our educational programming. You can find all the information about that at eli.org. And with that, I will bring today's webinar to a close. Thank you again, everyone, and we hope you have a wonderful day.
I want to thank Sharon and Bob and Jay. I'm the beneficiary of this. I just want you to be clear.
And I would like to thank Gerald.
All right, take care.
Thanks again all. Great fun.